Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Well, thank you for joining us today on this edition of Triage. My name is Myla Reizen, and I'm a partner in K&L Gates. I'm in the Miami office where I practice healthcare law and where I've been practicing for a significant amount of time and representing a number of healthcare clients actually navigate a pretty complicated healthcare environment these days in an area that's focused on a number of healthcare providers, whether it's hospitals, whether it's labs. For purposes of today, though, we're focusing on labs, and the topic is medical laboratories under the microscope. And also, I'd like to introduce two of my colleagues who I've worked closely with and have the pleasure of working with on this podcast today. The first one from Research Triangle Park in North Carolina is John Lawrence. And John is a partner in the healthcare group as well. And he's developed very extensive experience in the False Claims Act litigation realm, as well as the investigation surrounding this litigation. He's joining us from the Research Triangle Park office, is also another partner, Bobby Higdon. And Bobby is a member of the Investigations, Enforcement, and White Collar Group, and he has spent nearly 30 years as a federal prosecutor, including serving on the U.S. attorneys for the Eastern District of North Carolina. And this experience that he has just provided so much help to the clients. This practical experience from the government enforcement side has just been a tremendous asset. He has, obviously, with his background, has extensive experience in investigations, including the False Claims Act and other healthcare enforcement as well. The three of us, along with many of our colleagues at K&L Gates, have worked together on collaborating on the regulatory side as well as the government enforcement side. Today, we picked a topic that all three of our paths have crossed one way or another, John, Bobby, and I, and really wanted to share this with you and have the listener have the benefit of all of this on government investigations and the increased focus for this realm of laboratories. And so today, as I mentioned earlier, the topic is the medical laboratories under the microscope. And we're really honing in on EKRA and other related topics under the umbrella of fraud and abuse. So with that, I'm going to spend just a minute giving an overview on the sort of fraud and abuse world of labs, and not to minimize the whole other world of healthcare regulatory analysis that can be done for all of the arrangements going on, whether it's billing and coding or whether it's other principles out there. But today we are going to spend the time on the fraud and abuse area. And there's always the start, there's always the kickback to remember, which everyone knows from both a federal and potentially a state perspective. But today we're going to spend some time on EKRA because we want to really focus on some of the questions we've been getting in some of the past we've been seeing. And what is EKRA? Well, EKRA is a federal statute that was passed the end of 2018. It's Eliminating Kickbacks Recovery Act. And it's a very broad act. It's not lengthy in its verbiage, but it is a very broad act and in some ways broader than the anti-kickback statute. It actually, and let me give you some examples of what I'm saying is first, it applies to the private payers and the private plans, in addition to the federal programs. Some of the exceptions that are allowed for or under the EKRA are different things that are somewhat in range with the anti-kickback statute. For instance, the marketing that would be analyzed under the kickback really needs to be honed in terms of for purposes of employees under EKRA and may be more strict under EKRA. Also, the safe harbors, that there is a specific exception under EKRA related to the anti-kickback safe harbor. And for the EKRA exception, it has to be the safe harbor that was in place at the time of EKRA. And now there's more recent changes to the safe harbor that allow it to be a little bit more flexible under the anti-kickback. So those are just a few examples to think about when you're analyzing EKRA. Also, there are recent cases out there that are really important to hone in on throughout the country, not in one place. I mean, I think this is a good time to turn it over, John, and for you to jump in on the cases side.
Thanks, Myla. When we think about lab enforcement over the last several years, I think it's important to highlight Operation Double Helix. Operation Double Helix is one of the largest healthcare fraud takedowns in the nation's history, and it occurred in and around September of 2019 and involved criminal charges against dozens of lab owners and personnel, marketing company personnel, telehealth company personnel, and in particular physicians, for alleged kickback arrangements surrounding what's called CGX testing or cancer genetic testing, which tests for whether an individual has certain genetic markers or genetic makeup that might predispose that individual to certain types of cancer. And as you can imagine, given the nature of the test, is highly reimbursed by federal healthcare programs, and in some cases, Medicare reimburses for each CGX test up to $10,000. So a highly lucrative and heavily reimbursed test. But Operation Double Helix essentially, again, focused on the arrangements between the various parties in what I'll call a triangle, again, with labs, marketing companies, and telehealth companies. And the DOJ has essentially alleged that the kickbacks that defined, in DOJ's views, the relationships at the heart of Operation Double Helix were driving the testing, the CGX testing that was occurring. And DOJ has alleged that the amount of CGX testing that occurred through these arrangements caused federal healthcare programs, particularly Medicare, to pay over $2 billion in reimbursements that the government claims should not have been paid because they were based on illegal arrangements. In terms of the lab portion of Operation Double Helix, the government has particularly focused on labs' arrangements with marketing companies, and because of those arrangements and that focus, the contracts that existed between labs and marketers, and in particular the payment structure. What the government has been particularly focused on in Operation Double Helix is the fact that labs were either overtly paying marketing companies on a per sample basis. And so for the CGX testing, it's based on swab samples from beneficiaries or from patients. And so in some arrangements, in many arrangements, labs were paying marketing companies per swab or per sample, which is obviously a kickback issue. There were also arrangements where labs were agreeing to pay marketing companies a percentage-based arrangement. So essentially, Lab A gets a certain amount of money reimbursed from Medicare and agrees with a marketing company that it's going to pay that marketing company 35 or 45% of that Medicare reimbursement based on the swabs that marketing company was able to secure for the lab to test and then bill Medicare and other federal healthcare programs. Also, in some cases, DOJ has alleged that the labs and marketing companies knew that paying per sample or on a percentage-based arrangement was a potential kickback issue, and so they tried to disguise those sort of arrangements by, in contracts, setting forth a flat fee. But the government alleges that flat fee was based on percentage or per sample arrangements that they tried to essentially back into through a flat fee. And so it's a really fascinating takedown in case in terms of the focus on those arrangements. It also, of course, has, as I alluded to a moment ago, really interesting iterations in terms of, or other aspects in terms of other kickbacks alleged between, in some cases, the lab and the telehealth company, and marketing companies and the telehealth companies, to try to essentially get doctors to allegedly rubber stamp CGX orders in a way that obviously is potentially medically unnecessary. Operation Double Helix has also involved allegations that labs were violating the 70-30 rule. Essentially, they were referring out their CGX testing to labs that had the sophisticated CGX testing equipment because their lab didn't have that equipment, and were doing so in a way that was to a certain percentage that was violative of the 70-30 rule. And while that's not a kickback issue per se, The government has used this reference lab usage in the 70-30 rule as part of painting a picture for some labs and the marketing companies and telehealth companies involved in Operation Double Helix to paint a picture of fraudulent arrangements and pervasive fraudulent issues. Myla.
Thanks, John. That's very helpful. And Bobby, I think it would be really helpful for you to take some of your experience and add to what you learned, both when you were one of the lead prosecutors in the area, as well as what you've learned in the private practice space.
Thanks, Myla. What John is talking about is, I think, sort of the tip of the iceberg, and that is that we're now in a really aggressive enforcement environment. As you know, the Department of Justice has kind of an evolving approach to the prosecution of particular corporations and how those prosecutions are to operate and what benefits the corporation may get depending upon how they respond to the investigation and any type of action that's taken against them. And so what we're seeing, we've been seeing for a number of years, but what we're seeing kind of ramp up now in the last year or two is a heightened focus on healthcare companies in general because of the heavily regulated nature of that industry, as well as the amount of government money that's involved in it. And so you're seeing an increase in these types of matters, particularly with respect to labs, as reflected in self-disclosures to the Inspector General. And so you're seeing a lot more of those. Those are generally based upon either investigations that are being conducted by corporations themselves or the result of internal whistleblowers. And I don't necessarily mean those that are active in litigation, but those that are raising their hand and saying there's a problem within the company, usually reflected in these types of marketing practices that John is talking about. You're also seeing increased civil and criminal investigations just on the part of the government using the traditional investigative agencies. And so there are a larger number of those types of matters. You're seeing, as I've referred to, evolving DOJ policy on how corporations are going to be addressed. And now for a company to get any type of benefit from the government, there is a requirement that they be very thorough in coming clean and disclosing whatever it is that is a problem within the operation of the company. It's also now being required that the company disclose the names and identities of any individuals who are involved in these matters in any way. And so that's a really onerous requirement if the company wants any type of benefit from cooperation and from the disclosure itself. While you referred to EKRA, and I know there's been an ongoing debate around the country as to whether EKRA applies to laboratories. And when you read the basic language of the statute, it's clear that it does. A number of people across the country have tried to argue that perhaps it doesn't apply outside of the opioid context, because that's, of course, the context in which it was enacted. And it seems very clear to us that it does apply regardless of the backdrop to the investigation. We're seeing the Department of Justice start to take action using EKRA as a tool, as we anticipated that they would. And so that's something that needs to be on everyone's radar. And then just bottom line is we're seeing labs being highlighted within the medical industry. Since 2019, there have been at least 7 instances where the Department of Justice has settled matters with labs on the civil side, and those have been pretty substantial settlements. Those having included, testing issues that turn on the medical necessity of the testing. It deals with the referrals that John is talking about, the marketing mechanisms that labs are using. It involves things like, kickbacks in general. It involves caps on deductibles so that you can basically limit the cost of the test, and they can be marketed as, the test that you're going to take is only $25, that type of thing. So these are very, very important issues for labs to take note of as they are working within a heightened enforcement environment. I should also add that many of the cases that the Department of Justice is resolving involve corporate integrity agreements, which are really invasive and onerous arrangements where the federal government monitors the operation of your business to ensure that there are not further problems going forward. And many of these agreements and arrangements last as much as 5 years. They're very expensive and very invasive. And so this is, it's a tool that the Department of Justice has had for a long time, but it's one they're taking increased advantage of and making increased use of. So that's the environment that we're operating in, and it's a heightened focus on the medical industry, but even more so on laboratories.
And thanks, Bobby. And I think the last phase of the podcast, we want to just touch on lab compliance and the future of labs. So, John, do you want to run with that?
Thanks, Myla. When we think about lab compliance, I think first and foremost, given the amount of enforcement that has been surrounding labs, one historically, but certainly recently through Operation Double Helix and through other enforcement actions, I think it's really important for labs to consult with counsel. While that might sound overly simplistic, it is essential. It is particularly essential for labs to consult with counsel, as we've highlighted, surrounding arrangements that labs might have with third parties, particularly marketing companies, to have counsel vet those contracts and arrangements to ensure that they don't violate the anti-kickback statute or other laws and regulations. As we mentioned with Operation Double Helix, a central focus of that takedown has been those arrangements between labs and marketing companies, particularly concerns over per sample or percentage-based arrangements or arrangements that are flat fee, but essentially are allegedly to hide percentage-based or per sample arrangements. So it's really important to have counsel take a look at those. Not only take a look at those, but it's really important that labs provide counsel if they are seeking legal advice, all material information surrounding the lab's arrangements with third parties. In other words, don't leave anything out. Tell your lawyer everything about the arrangements so your lawyer can take a really close look to ensure that those arrangements are legal. And if there are issues, that the lawyer can address those issues and help your company, your lab, correct those. And then finally, once your counsel gives you advice based on the information you've provided, which it would be fulsome, we advise to be fulsome, then you need to follow that advice. And the reason why those steps are important, retaining counsel, providing counsel all material information, and then following the advice that counsel gives, is because if there's an enforcement action later surrounding those arrangements, the lab can say, I consulted with counsel, I apprised my counsel of these arrangements, and my counsel gave me advice that I followed as closely as possible. And that can create what we call a good faith defense, or in some cases, an advice of counsel defense, which can show you didn't have the intent to violate the anti-kickback statute, or you didn't have the intent to violate EKRA potentially, or other laws and regulations. So I think first and foremost, consulting with counsel is really important. I think it's also really important to have counsel take a look at your compliance program. As Bobby alluded to, DOJ expects that labs have robust and sophisticated compliance programs, and counsel can help you do that and help you ensure that you're meeting DOJ's expectations. I'll also say, just finally, a good way to track what the government expects labs to be doing and not doing, and also to track areas where the government is particularly focused as far as enforcement in the lab space, is to take a look at the corporate integrity agreements, or CIAs, that Bobby was referring to earlier, that OIG has agreed to with in particular, in this case, labs. Those CIAs are incredibly detailed. They're publicly available on OIG's website and often include claims-related monitoring, arrangements-related monitoring, and other types of policies and procedures that the government expects labs to have, and also areas in which the government is particularly focused monitoring. And so that can often give insights to labs that aren't under a CIA, what they need to focus on, in particular, have their counsel take a look at. Thanks, Myla.
All right. Thank you, John. So I think with that being said, we want to just wrap it up with, in summary, you could see that obviously the lab industry is a very unique area and highly regulated at this point in a number of areas, but particularly the fraud and abuse. And the trend is unfortunately, considering the statutes and the increased framework of the enforcement we talked about, is going to continue down that path. So we're going to continue to provide updates as we see them on our end, but just wanted to thank you for listening today. And any questions that you have, feel free to reach out to any one of us. Thank you so much.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.